Deputy Mayor, President and Mrs Fitzgerald, Chancellor Emeritus, members of the Governing Authority, distinguished guests, colleagues and friends. It is my great pleasure to welcome you this evening to the inaugural UL Forum lecture, which will be given by perhaps one of the most generous people I have had the pleasure to meet, Mr. Philippe Sands. I would like to call on my colleague, Professor Shane Kilcummins, the chair of our law school, to give an introduction, not an enviable task, a very difficult thing to do, to introduce to you Mr. Philippe Sands.
Good evening, everyone. I should say at the outset that I'm very honoured to be asked by the President, Dr. Des Fitzgerald, to introduce Professor Sands this evening on what is a special occasion for the University of Limerick as a University of Sanctuary. It is a real privilege for me. I know that the inclusionary ethos that underpins UL's status as a University of Sanctuary means a lot to our President and to the staff that have supported him in ensuring that this University of Sanctuary status was brought about. So it is a pleasure for me to be here for that reason alone. It is also nice to be here to endorse the work that has been done by the President and his team behind the scenes, putting in place the financial support plans, the plain English provision plans, and the safe spaces that are necessary to create this pathway for a University of Sanctuary. To paraphrase Seamus Heaney, the President and his team are ensuring and have ensured that the book stands open and the gates unbarred. And to date, I was just speaking with Mairead beforehand, I think 24 students have already accepted scholarships onto that programme, so the gates are definitely unbarred. I'm also very grateful to my colleague, Dr. Mairead Moriarty, for the opportunity to attend. She also has done sterling work in bringing about this University of Sanctuary scholarship programme. I'm very proud to say that she's a colleague of mine in the faculty, and it's a pleasure to work with her, and it's a faculty which I think contributes richly to the life of the university. So as Mairead has mentioned, I've been tasked with this inevitable task of trying to introduce Professor Sands. It's not been helped by the President telling me just before we started, have you seen his CV and how are you going to do this? Safe thing for me to do, obviously, would be for me to simply read his very long list of very impressive and significant achievements. How he's read for his law degree at the University of Cambridge, and how he's worked in the University of New York, Boston College, University of Toronto, University of Melbourne, King's College London, and currently University College London. How it acts as a Queen's Counsel, and how he's appeared before many of the great courts of this world, including the European Court of Justice, the European Court of Human Rights, the International Criminal Court, the International Court of Justice, and so on. How he also sits on so many international panels and commissions, and how the work he has done with the Matrix Chamber, which was set up in 2000 with a colleague from Ireland, Professor Conor Gearty, and a very exciting project around constitutional rights and human rights. He's also represented many states in his work and has published more than 16 books. So to try to do honour to him this evening, to do honour to the occasion and to you who are in attendance, I'm going to provide you with 3 very short vignettes which will, I hope, demonstrate to you his impressive ability and the breadth of his work. And the vignettes are shaped around 3 very simple titles. One is a quote from him, and the second relates to climate change, and the third relates to a concept which might be called a rights-based conception of the rule of law. And so just to begin with the quote, in 2005, in the European Court of Human Rights judgment, a decision was made in the Hurst judgment which said that a blanket ban preventing prisoners in England and Wales from voting was disproportionate. It was disproportionate because it was a blanket ban and because of the disenfranchisement which ensued. And This caused consternation not only in the UK but also in this country. And for a long time around law and order, in particular in Western countries, it had become much more politicised, starting in the States with Barry Goldwater and Nixon, moving on to the New Right, the Conservatives in the early 1970s. And so there was a currency to be seen in being tough on crime and tough on the causes of crime. And so it was in that context then that the decision of Hearst was viewed by some in the UK, and the argument was that it was a European court that failed to recognise parliamentary sovereignty, that it facilitated terrorists, criminals and foreigners. And so some 6 years later a commission was established, of which Professor Sands was a member, and the commission was set up to introduce a Bill of Rights for the UK. And this Bill of Rights was designed initially to enhance and augment the European Convention of Human Rights. It became clear very quickly, however, that that was not what was going to happen, that in fact it was possible or probable that a decoupling exercise would take place, that this Bill of Rights would be decoupled from the European Convention of Human Rights and would result in a diminution of rights for UK citizens. And so in a very powerful dissenting article entitled In Defence of Rights, Professor Sands and his colleague Baroness Helena Kennedy produced the following statement. I'm just going to read 2 sentences from the statement. For us, human rights is about working not just within our own country, but with other countries to improve the human condition, to engender respect for all individuals, to protect those who are vulnerable, and to create the conditions for the delivery of justice and peace. To remove the glue that holds us together with other nations is dangerous. Our criticisms of the European Court should galvanise us to reform it, not lead to our cutting ourselves off. Now you can read this entire defence in the London Review of Books. It's not very long, but it's very powerful. And for me, 4 messages strike in just in reading those 2 sentences alone. The first is that it's a compelling dissent, and that Professor Sands is not afraid to be a dissenting voice. I think even today it could be argued with the Home Secretary that he's not afraid to be a voice, to champion rights. Second, you could argue that it's prophetic, given what subsequently followed, because that statement was written in 2013. He doesn't strike me as the kind of man that will engage in I told you so's, but I do think that it's prophetic. The third dimension, which I think is interesting to the quote, is that it's a defence of rights, but it's not starry-eyed. There is no suggestion that because something is reified as a right, that it is beyond review. He accepts that law reform is always necessary, indeed always possible. And finally, the fourth dimension, I think one of the reasons why we're here tonight, is his openness to the other. This openness to the other is vital. If you've been around rights discourse, or if you study systematic rights violations, you will realise that the tactic of othering, seeing others as being different from you, dehumanising them, is often one of the fastest and easiest ways to deny people rights, to remove or dilute people's rights, or to create special zones where rights do not exist. And so that often happens through a process of authorisation, routinisation and dehumanisation. But to end on a positive note in this vignette, that openness to the other is why we are here tonight. Being here tonight to celebrate UL as a university sanctuary speaks to that openness, to that inclusion of others, to a spirit of welcome in this house of intellect. The second vignette, and I'll be very quick, relates to climate change. I have chosen this from Philippe's work, as climate change is a driver of migration, forcing people to flee their homes and to seek refugee status. There are some who still challenge the notion that climate change is occurring. They deny that it's occurring, or they deny that human agency is a factor, or they deny that there's any possibility that we can do anything about it. It's a difficult problem for law, because climate change extends beyond jurisdictional boundaries and beyond sovereignty. It's obviously something that affects us all, and will affect us more in the years to come. One would think in these circumstances and if we're thinking about the issue in terms of a morality of aspiration, that all states and citizens would come together and come up with agreed and legally binding solutions. After all, it is vital for human flourishing. This has not happened. Indeed, Noam Chomsky, in a recent piece directed at all of us, but in particular at the Trump administration, suggested that we are now putting Nero, the Roman emperor, into the halfpenny place, into the shade. After all, he only fiddled while Rome burned. And he points out that the irony of a president seeking planning permission to build a huge wall for a golf course not far from here, on the basis that it is threatened by sea level rises as a result of global warming, whilst confusing public opinion and delaying decisive action more generally, is a dangerous thing. So what can we do? In an address at a 3-day conference at the UK Supreme Court in 2015, Professor Sands, in a paper entitled Climate Change and the Rule of Law, gives us what I think are very effective solutions and presented in a very pragmatic way. And he talks about the way in which law and science can combine to circumscribe or limit some of the post-facts that have been emerging. One of the key solutions for him is to start using the courts, such as the International Court of Justice, but not just in terms of legal determinations, but rather in terms of making judicial determinations about facts. And so in terms of those facts, what is he talking about? And he ponders what might be established. And he asks questions. We could, for example, determine that climate change is underway, that sea levels have risen, that greenhouse gas emissions have been the main cause of atmospheric warming, that emission reductions are needed. This approach is compelling. It is solution-focused, recognising that we live to some extent in a post-fact world. Legalising or druidifying climate change would act as an emboldening reference point, a point of solidarity. It would confirm the conclusions of science and most scientific experts, but wrapping it in the last voice, the authoritative voice of law. In this way, it would settle scientific argument, and this in turn would facilitate the disposal of future actions and would frame negotiation strategies. All of this would be a normative guide to action. And finally, and just to finish on this point, it's the concept. And I think, and I discussed this with him earlier just to make sure that he was happy with this. So he's written 2 books, he's written 16 books, but 2 of the books I'm going to focus on. One is a 2005 book called Lawless World, and the other is a 2008 work called Torture Team. And in the 2005 book, Lawless World, he suggests that there was no basis in international law for the invasion of Iraq in 2003. And he goes on to document the US's, retrenchment from international agreement over a period of time. In Torture Team, he examines the role of senior lawyers in authorising torture, or otherwise referred to as enhanced interrogation techniques. And he contrasts that with the Atlantic Charter, which was agreed between Roosevelt and Churchill in Newfoundland in 1949, which set forward a vision for a post-Second World War world that included much more international agreement, a much greater concentration on rights, and a much greater consensus around the need to prevent war. For Professor Sands, and for me, in interpreting his work, the rule of law is not just about logical consistency regarding rules. After all, we can change rules very easily, or we can create exceptions around those rules, or we can create special zones where those rules do not apply. His version of the rule of law is a rights-based version, which commands that rules in the rule book both capture and enforce moral rights, and obviously then in the concretized form as human rights. And so it would be not surprising for you to know that in terms of his books and his book sales, not only has he sold thousands of copies, he's sold hundreds of thousands of copies. And so on that note, I would like to welcome him to the stand.
Thank you very much, Professor, for coming, Shane, for that incredibly generous introduction. I think those of you who know me will know that Ireland occupies a very special place in my being. My wife and I do not hesitate to accept opportunities to visit Ireland, and it is incredibly nice to make this first visit to Limerick. I'm especially grateful and privileged, I would say, to be here at the invitation of the President to celebrate the university's role in providing sanctuary, in creating a University of Limerick sanctuary programme. And I've spent time over the course of today with Professor Moriarty, and some of the students who are with us today, exploring what this means in practice. It's an astonishing programme. I spent an hour or two over lunch with 3 of the students who are here with us now, Donna and Ruth and Momobo. And it's really to them and to their generation and to others like them in this country, across our Europe and across the world that I dedicate this lecture. It is wonderful to be in Limerick. We are here in this wonderful building and wonderful room as a group, but each of us is, of course, an individual. And I long ago came to understand that my various activities, which were addressed, teaching, writing, litigating, are engagements that were informed by my personal background, by baggage that was attached to me when I came into the world, as baggage is attached to each of us. I was not a blank slate. None of us are blank slates. A point recognised by the historian Eric Hobsbawm in his wonderful autobiography, Interesting Times. He recognised in that book the complex connection that exists between who we are and what we do. He noted the profound way, as he put it, in which the interweaving of one person's life and times and the observation of those life and times help us to shape historical analysis. I'm not a historian, I'm a lawyer, and I focus on matters international. My professional and academic interest is to understand how the law functions, how rules come into being, how they are interpreted, applied, how they affect the behaviour of international actors, from individuals to states and everyone in between. I'm a curious person, and I'm curious about a person's life and times, how it might inform the world, and the experiences of the past quarter of a century in my work, not least in the courtroom, appearing before many international judges, has taught me a number of things. One of them is that individual lives and personal histories really matter, and they really can make a difference. My book, East-West Street, took nearly 7 years to write. It's not about the life of one person, but about 4 individuals, and it seeks to understand how the particular circumstance of each of those 4 individuals contributed to the roads he took, and how the different roads thus travelled changed the system of international law that is my daily work. As many of you will know, the book also touches a more personal theme, how these 4 interweaving lives influenced my path, whether directly or indirectly. And embedded in the book are a series of bigger questions, questions that touch each and every one of us in this room today, central questions of human identity. Who am I? How do I wish to be defined? As an individual or as a member of one or more groups? And how do I want the law to protect me? Do I want the law to protect me because of my individual qualities or because I happen to be a member of a group? These are pertinent questions, as pertinent today as when the concepts of crimes against humanity and genocide were coined back in 1945. In a way, East-West Street came about entirely by chance, like a lot in life. It was the spring of 2010. I was immersed in my activities, classroom at UCL, writing academic articles, doing cases in The Hague. An invitation arrived from the Ukraine, an email from the law faculty of the university in a city that was once called Limerick in the Austro-Hungarian Empire till 1918, then Lwów when it was part of Poland until 1939, and then after 1945, Lviv. Would I care to visit and deliver a public lecture on the work I do on crimes against humanity and genocide? Would I care to talk about the cases in which I've been involved, my academic work on the Nuremberg Trial and the trial's consequences for our modern world? Yes, I replied, I'd love to. I'd long been fascinated by the trial, by the myths of Nuremberg, the words, the images, the sounds. The trial was a catalytic moment in which our modern system of international justice, such as it is, crystallized into being. I was mesmerized too by the points of detail in the transcripts, by the terrible evidence, drawn to the books, the memoirs, the diaries that described in forensic detail the testimony that was laid before the judges, the love affairs that went on behind the scenes. I was drawn to films like Judgment at Nuremberg, which won an Oscar for Best Film in 1961, made memorable by Spencer Tracy's momentary, unexpected, fantastic flirtation with Marlene Dietrich, and the line from his closing judgment in the scene: "We stand for truth, justice, and the value of a single human life." But there was also a practical reason for my interest, because the trial's influence on my work had been profound. Nuremberg blew a wind into the sails of a new human rights movement. Sure, there was a whiff of victor's justice, but there was no doubting how catalytic the case was. It opened up the possibility, for the first time in the history of human beings, that the leaders of a country could be put on trial before an international court. That had never happened before. It was probably my work as a barrister, rather than my writings, that caused the invitation to arrive from Lviv in the Ukraine. In the summer of 1998, I was involved in the creation of the International Criminal Court, a body that would have jurisdiction over both the crimes of genocide and crimes against humanity. The essential difference between the two concepts is on who is protected and why. Assume that 10,000 people are killed. The systematic killing of such a large number of people will always be a crime against humanity. But will it be a genocide? That depends on the intentions of the killers. It is necessary to show, to establish the crime of genocide, that the act of killing is motivated by a special intention to destroy a group in whole or in part. If a criminal prosecutor cannot prove that intention, it will not be genocide under international law. And so you've got these two concepts operating side by side: crimes against humanity, genocide. Every genocide will be a crime against humanity, but not every crime against humanity will be a genocide. A few months after the two crimes were inscribed into the statute of the International Criminal Court, Senator Pinochet was arrested in London on charges of genocide and crimes against humanity brought by a Spanish prosecutor. I was involved in the proceedings before the House of Lords, which ruled famously that as a former president of Chile, he was not entitled to immunity from the English court for crimes of such a nature. The judgment was totally revolutionary. In the years that followed, the gates of international justice creaked open after 5 decades of quiet during the Cold War. Cases from the former Yugoslavia and Rwanda landed on my desk in London. Others followed, allegations in Congo, Libya, Afghanistan, Chechnya, Iran, Syria, Lebanon, Sierra, Leon, Guantanamo, Iraq, and a myriad of other places. These were all based on the rules that came into being after 1945, a revolutionary moment in the making of modern international law, when for the first time it was recognised that the sovereignty of states over its people was not unlimited. But the long and sad list of cases that reached my desk in London reflected the failure of good intentions, aired in courtroom 600 of Nuremberg's Palace of Justice. I became involved in too many cases of mass killing. I saw too many mass graves. Some concerned crimes against humanity, some concerned genocide, some concerned both the protection of the individual and the protection of groups. The two distinct crimes, with their emphases on the individual and the group, grew side by side, although over time, genocide seems to have emerged in the eyes of many as the crime of crimes, a hierarchy, perhaps it is the magic of the word, that left a suggestion that the killing of large numbers of human beings as individuals was somehow less terrible than killing them as a group. Occasionally in my work, I pick up hints about the origins and purposes of the two terms and the arguments made in courtroom 600. But I never really inquired too deeply as to what exactly had happened in Nuremberg. I knew generally how the crimes had come into being, but little about the personal stories behind them, or even how they were argued in the Nuremberg trial. And so the invitation from Lviv gave me a chance to research that history. Now, I could say that I made the trip to give a lecture, but that would not be accurate. I travelled for another reason. The young boy you can see behind me, my grandfather, Leon Bohov, aged 10 in 1914. He was born in that city, Limerick, as he called it when he spoke in German, Lvov when he spoke in Polish. The wonderful poet Joseph Witlin, also from Limerick, published a book, Mój Lvov, My Lvov, now translated in English 70 years after it first came out in 1946, called in English The City of Lions. And he in that book tries to describe what it means to be a Lvovian. An extraordinary mixture of nobility and roguery, he writes, wisdom and imbecility, poetry and vulgarity. But, he continues, nostalgia likes to falsify the flavours. It tells us to taste nothing but the sweetness of the city of Lvov today. I know people, he concludes, for whom Lvov was a cup of gall. And it was a cup of gall for my grandfather, buried deep, part of a hidden hinterland of which he never, ever spoke to me or my brother. His silence barely covered the wounds of a family that he left behind in 1914 when the Russians occupied the city and he moved to Vienna and then lost forever after 1939. Yet the moment I first set foot in the city in the autumn of 2010, it felt incredibly familiar, like a sort of long-lost relative. The dark city was somehow part of my DNA. I'd missed it, and now I felt comfortable there. Why did I have that reaction? That question caused me to explore psychoanalytical writings that address the relationship not between parent and child, but between grandparent and grandchild. And I was directed to the writings of two Hungarian psychoanalysts, Maria Torok and Nicholas Abraham, who spent their lives looking at the relationship between grandparent and grandchild. They wrote, "What haunts really are the gaps left within us by the secrets of others." And it is their words with which East-West Street open. My grandfather Leon's secret was that he actually came from a huge family, one that was centred in the city of Limerick and small town round called Genealogy. The family grew and grew. Dozens of uncles, aunts, cousins, nephews, nieces, and more distant relatives. Then war came into the city in 1939, and within 6 years, by 1945, he was the only member of that family still alive, the only survivor from Limburg and from Galicia. In 1939, he was banished from Vienna because he was Jewish. He moved to Paris. And when I came into the world and came to know him, that was where he lived with his wife, my grandmother. For me, he was always a Frenchman because he never talked about what happened before the war. Preparing to go to Lviv for the first time, I asked my mother if she had any papers, and she said she did. And amongst them, I found the actual order expelling him from the German Reich. Translated into English, it says, and I quote, "The Jew, Buchholz Maurice Leon, is required to leave the territory of the German Reich by December the 25th, 1938. The reason he could be expelled is that a short time earlier he had been made stateless. That is one of the reasons, no doubt, I feel as strongly as I do. Some of you may have listened to the Today programme this morning about a country that strips its own people of nationality and makes them stateless, particularly since in 1961 the UK led the world in determining by an international convention on the reduction of statelessness that it is impermissible to make any human being stateless. That is why I object to the decision referred to or alluded to by Shane earlier of the British Home Secretary to strip a person who has obviously been involved in unfortunate things of her nationality, Shamima Begum. I had always assumed that my grandfather had left Vienna after that expulsion order with his wife Rita, my grandmother, and his one-year-old daughter Ruth, my mother. But in the course of research, having had the documents made available to me by my mother, I learned that this was not in fact the case, and that this central fact probably lay deep, touching my family and my own childhood in the silences with which I grew up. In fact, Leon left Vienna in January 1939 alone. He made his way to Paris by himself. In gaining access to these papers, I learned that his daughter, my mother Ruth, had travelled to Paris a few months later, in July 1939, and that his wife, Rita, had remained in Vienna for another 3 years. From this material, with the instinct of a litigator, I formed a sense that something else must have intervened in their lives before the three separated in January 1939. I had questions. Why did Leon leave Vienna by himself? How on earth did my mother get to Paris, an infant of less than a year, by herself? Why did my grandmother remain in Vienna, allowing herself to be separated from her only child? These were big questions, and they hung in the air as such questions necessarily would. I returned to the documents, and I found amongst the on-papers clues. As a litigator, you are sort of a lesser amateur historian come psychiatrist, and you learn that every scrap of paper, every photograph is capable of hiding information that is not immediately knowable. It's called the muck of evidence, and I love it. I have learned to keep an open mind, to look at things very carefully not to prejudge, to attend to the unexpected, to find the dots, to try to join the dots, and to be persistent. Because nothing is ever only what it seems. And two items stood out. This was the first one, actually a tiny scrap of thin yellow paper, folded in half, blank on one side, with sharp, angular, firm writing in pencil on the other. Miss E.M. Tilney, Manuka, Bluebell Road, Norwich, Angleterre. And this was the second item, a small black and white photograph taken in 1949. Not quite square, a middle-aged man looks into the camera, a faint smile across his lips. He wears a pinstripe suit with a white handkerchief neatly folded into the breast pocket. On the back of the photograph, in blue ink, are written the words, Herzliche Grüße aus Wien, September 1949. Warmest wishes from Vienna. And there is a signature, but it is indecipherable. I asked my mother about those two items. Who was Miss Tilney, and who was the man with no name in the photograph? She said she didn't know. I didn't believe her. I retained the scraps of paper. Perhaps they would shed some light in due course on what exactly happened to my grandfather in 1939. I pinned them on the wall above my desk. They stayed there for 4 years as I turned to the lecture that I had to write, a lecture on crimes against humanity and genocide to be delivered in Lviv. So let me take you, in relation to that lecture, to the first of several coincidences, as I prepared it back in the summer of 2010. I was, frankly, immensely surprised to learn the man who put crimes against humanity into international law actually came from the city of Lviv. Not only that, he was a student at the university that had invited me to deliver the lecture at the law faculty, but the people who had invited me were unaware of that fact. How extraordinary, I thought, that I shall turn up and share this discovery. His name was Hirsch Lauterpacht, and he was actually born in the small town of Żółkiew. Remember the name. It's about 15 miles north of Lviv. He moved to Lviv in 1911, enrolled at the law faculty 4 years later, and in 1919, with his first degree in his pocket, moved to Vienna, where he studied with the renowned professor of jurisprudence, Hans Kelsen. He arrived in London in 1923, newly married, became an academic, first at the LSE and then at Cambridge University. In 1945, he published a book that laid the foundation for our modern system of human rights, with the title An International Bill of the Rights of Man. And it offered a revolutionary idea. Every human being on the planet, Lauterpacht posited, has minimum rights under international law simply because they are a human being. That was totally radical and novel. He prepared 20 draft articles, the first of their kind, new but certainly not exhaustive. By more contemporary standards, there were notable omissions. No reference to the prohibition on torture or cruel treatment. No obligation not to discriminate against women. And equally striking was the approach he took to the situation of non-whites in South Africa and what he called, and I quote, the thorny problem of the disenfranchisement of large sections of the Negro population in some states of the United States. Lauterpacht was a realist. He recognized the realpolitik of the situation. In any event, the draft bill gave effect to his personal credo: the individual human being is the ultimate unit of all law. In April 1945, after the war in Europe ended, Churchill, Roosevelt and Stalin agreed there would be a criminal trial for senior Nazi leaders. The British team hired Lauterpacht to join the prosecution, to work with Robert Jackson, a Supreme Court Justice of the United States, who would be chief prosecutor. In July 1945, Jackson travelled to London to draft the charter of the Nuremberg Tribunal. The four powers couldn't agree on the list of crimes over which the tribunal would exercise jurisdiction, and so Jackson turned to Lauterpacht for help. On July the 29th, 1945, Jackson was driven up to Cambridge to have lunch with the Lauterpachts. They sat in the garden of Lauterpacht's home. Here you can see Lauterpacht in his beloved garden. The two men discussed the problem of the list of crimes. Lauterpacht suggested it would be a good idea to insert titles into the charter. That would help public understanding and grant greater legitimacy. Jackson was positive, so Lauterpacht offered another idea in respect of atrocities committed against civilians on a massive scale, a matter on which the Soviets and the Americans were deeply divided. Lauterpacht, of course, had a long-standing academic interest in this subject, but also a personal interest, because he had no news about his family in Limerick, a matter on which he said nothing to his colleague Robert Jackson. Why not, he said, why not refer to crimes against civilians as crimes against humanity? Crimes against humanity. Here you see it in Lauterpacht's own hand. The term will cover atrocities against individuals on a massive scale: torture, murder, disappearance, introduce a new concept into international law, never been used before. Jackson liked the idea, took it back to London, and within a few days, on August the 8th, crimes against humanity was incorporated into the Nuremberg Charter, the first time it had ever been used. It signified, in Lauterpacht's words, that anyone who broke international law and harmed individuals could not shield themselves behind the law of their own states. Now, I also had to address the subject of genocide, and this brings me to the second immense surprise. The man who invented that word, genocide, in 1944, also came from Lviv and also studied at the very same law school as Lauterpacht. His name was Raphael Lemkin. He arrived at Lviv University in 1921, 2 years after Lauterpacht left, and remained there until 1926, leaving with a doctorate in criminal law. Amazingly, the people who invited me to Lviv were unaware of his connection to the university. After law school, he became a public prosecutor in Warsaw. In 1933, he wrote a paper for a League of Nations meeting proposing new international crimes to combat what he called barbarity and vandalism. His focus, however, was not on the protection of individuals. It was on the protection of groups. His ideas bounced around, but nothing came of them. The timing was not ideal. Hitler had just taken power in Germany. In 1939, when Germany invaded Poland, Lemkin was in Warsaw. He escaped, made his way to Sweden, then under Soviet control, and he left Sweden in 1941 for America to become an academic refugee. As Europe was closed, he travelled the long route across the entirety of the Soviet Union to Japan, by boat to Seattle, and then by train to Duke University, Durham, North Carolina, where he had been offered a place of academic refuge. He travelled impecunious and with no personal belongings, but a vast quantity of luggage. Suitcases filled with bits of paper. He had been collecting, whilst in Stockholm, thousands of decrees promulgated by the Nazis in the countries they had occupied across Europe. He gathered this material and then carted it around the world. In 1942, in America, he was offered a contract to write a book that would describe the patterns of behaviour he had found. He was looking for an underlying master plan. The book was published in November 1944 with the title Axis Rule of Occupied Europe. It was in many chapters, and to chapter 9 he gave a new word as the title. Genocide. Here you see it in Lemkin's own hand. He had invented this word, the crime of the destruction of groups, a Nazi master plan, an amalgam of the Greek word genos, meaning tribe or race, and the Latin word side, meaning killing. In the summer of 1945, Lemkin was hired by the US government to work on war crimes, and he began work with Robert Jackson and his team, although totally separately from Lauterpacht. He pushed his idea of genocide. He wanted the senior Nazis to be indicted for his crime, the destruction of groups, Poles, Roma, Jews. In August 1945, he would be greatly disappointed when genocide did not make it into the Nuremberg Charter. He flew himself to London, persisted, and for the drafting of the indictment of the individual defendants, succeeded in getting the term incorporated. He fought his corner successfully, persistent. There was terrific opposition from Jackson's office, under pressure from southern US senators who were concerned about discrimination against African Americans who might use the term against the United States, and the British were deeply concerned about the possible use of the term in relation to Britain's colonial legacy. But against the odds, the word made it into the indictment, and it included his definition. This was the very first time the word was used in any legal instrument anywhere, and it came, as I said, with his definition, the extermination of racial and religious groups. The Nuremberg Trial opened on November the 20th, 1945. Lauterpacht was present in the courtroom with the British team on that opening day, pushing for the protection of individuals, crimes against humanity. Lemkin remained in Washington with the American team at home, pushing for the protection of groups, genocide. One of the 22 men in the dock was this one, Hans Frank, who became the fourth man in my story. He was a lawyer, educated at some of the best universities in Germany. From 1928, he served as Adolf Hitler's personal lawyer. In 1933, he became Minister of Justice in Bavaria. In October 1939, he was appointed Governor General of Nazi-occupied Poland. In August 1942, he visited Galicia and the city of Lemberg, which had been incorporated a year earlier into the Government General. He hosted a concert, Beethoven's Ninth Symphony, and gave a series of speeches in which he announced the complete and total elimination of the city and the region's entire Jewish population. Hundreds of thousands of human beings would be killed in the days and weeks that followed Frank's visit. They included the families, friends, and university teachers of Lauterpacht and Lemkin, as well as my grandfather's entire family. For each family, there was only one survivor. In this way, Frank became the glue that linked the lives of the three other men in the story of East-West Street. Frank, it has to be said, was not unduly perturbed by such actions, but more bothered by other mundanities. He stayed that period at the home of his deputy, Otto von Wächter, governor of Galicia, who, as some of you will know, is the principal character in a BBC radio and podcast series that I made last year, which is called The Rat Line. Indeed, the book that follows from that podcast will be published next year as the sequel to East-West Street. I came to know Otto Wächter's son, Horst, who gave me a copy of his mother's diary. Frau Charlotte von Wächter wrote about what happened on the day that Frank visited to announce the elimination of 500,000 people. She played chess with him, and I quote, "I won twice." Frank was angry. He went to bed. Then he came back downstairs and drove away immediately. Just 3 years later, Frank was apprehended by the American army near his home south of Munich. He had with him his diaries, 42 volumes, and a fantastic collection of artwork. When I say fantastic, I mean fantastic. It included this portrait of Cecilia Gallerani, the lady with the ermine, painted by Leonardo da Vinci in about 1489. This painting hung in Frank's private office in the Wawel Castle in Krakow, and when he left, he took it with him to his home near Munich. Some of you may have seen it, either in Krakow, where it now hangs again, or when it hung in London at the National Gallery as the centrepiece of the Leonardo exhibit. Frank's son, Nicholas, who I've come to know when I went to visit him with him, told me a story about how, as a little boy, his father would make him stand in front of this painting and slick down his hair like Cecilia Gallerani. And now Frank was in the dock, accused, charged on 3 counts, including crimes against humanity and genocide. On the first day of that trial, the Soviet prosecutors took the judges to events in the city of Lviv following Frank's visit. The prosecutors described terrible acts of murder and torture and other ill treatment, and described them as acts of genocide. 130,000 people killed in a short period of time, including 8,000 children murdered in 2 months, right in the centre of the city. As the words were spoken, Lauterpacht and Lemkin heard them, but they did not know whether the victims included their own families. Remarkably and painfully, they were not yet aware that the man they were prosecuting, Hans Frank, was directly implicated in the destruction of their own families. But on this day, for the first time, terms genocide and crimes against humanity were used in an open court. I knew Lauterpacht and Frank to be in courtroom 600 on that day, and I wondered if there was a photograph. Lauterpacht's son Ellie told me there was no photograph, but as with my mother, I did not believe him, and I persisted in hunting for one. A friend introduced me to the archive of Getty Images, the largest collection of photographs from that first day in court. I spent the whole day going through hundreds of old glass plate images. Each one had to be removed from its protective paper sleeve. And after several hours, I found what it was I was looking for. If you look in the top left-hand corner, at the end of the British table, you will see Hirsch Lauterpacht. Elbows on the table, hands clenched under his chin, attentive, standing behind counsel's lectern, listening to a Soviet prosecutor describe what happened in Lemberg. Then if you move your eyes to the lower right-hand corner, you'll pick up the familiar image of Hermann Goering in the traditional oversized light-coloured suit. Move along the bench to his left, 6 along, and just before the image is cut off by a protruding balcony, you can see the semi-bowed head of Hans Frank. I find this photograph very moving, divided by no more than a few tables and chairs, Hirsch Lauterpacht and Hans Frank together in the same room. The trial lasted for a full year, and judgment was handed down over 2 days on September the 30th and October the 1st, 1946. You'll understand that I don't have time this afternoon to reveal everything that transpired in the course of a remarkable year as the lives of those three men, Lauterpacht, Lemkin, and Frank, became increasingly intertwined. Suffice it to say that the connections were entirely unexpected. A series of happenings which the historian Anthony Beevor has described as being of a kind that no novel could possibly ever match. The point I make is that those personal journeys coincided in ways that produced an outcome to change the course of legal history, and then history itself. The ideas and endeavours of Lauterpacht and Lemkin influenced politics, history, culture, my life, and your lives. I am able to share with you one document that I've never talked about before, which I found in the scrapbook drawn after each day of the trial by the wife of the presiding judge, Sir Geoffrey Lawrence. Marjorie Lawrence kept a clippings file of everything that had happened. And in August 1946, she pasted into the scrapbooks, which I found in Wiltshire, a document that was written by the deputy British prosecutor, David Maxwell Fyfe. It was a poem dated August 1946. And I gleaned from its existence in the scrapbook that, contrary to the kind of rules I would apply in my courtroom today, somehow the prosecutor had communicated a poem to the chief judge of the trial in the middle of the trial, something for which I would be severely reprimanded. I hesitated as to whether or not to read it out, but it does connect to Ireland, and so I will read it out now for the first time. This is the poem that David Maxwell Fyfe passed to Sir Geoffrey Lawrence, based on a well-known poem by Percy French, in which he changed the words. There is one man called Pule and another called Pole. If you ask them a question, they answer, Jawohl. But I shouldn't care if they only said, Nein, if I could only get out of this humble shrine. There are some who talk Russian and others talk French, and German streams from the advocate's bench. That's why I want the silence that's waiting for me, where the mountains of morn swept down from the sea. It was, in many ways, an incredible and unique trial. It was also the trial at which the concepts of crimes against humanity and genocide entered our world, although many people imagine that those two concepts have existed since time immemorial. They haven't. They're the product of creative minds. They are inventions. Inventions of two men driven by their own terrible experiences, forged on the anvil of a single city of Limerick, Lviv. Why Lauterpacht opted for the protection of the individual and what caused Lemkin to embrace the protection of the group is a matter of speculation. Their backgrounds were similar. They studied at the same university. They had the same teachers. Indeed, if you want to trace the origins of these two concepts, these two crimes, you can trace them to the city of Limerick, to the events at the end of the First World War, and to the city's law faculty. Indeed, you can even trace the crimes and their origins to a single teacher the two men had in common, Professor Julius Makarevich, teacher of criminal law. You can follow the line even to a particular building, as I have done, and find the very classroom in which Makarevich shared his ideas on the treatment of minorities and groups and individuals. It is, as you can see from the photograph, still a working classroom today, unchanged from how it was 100 years ago. There's something else that strikes me as remarkable. Despite the common origins of the two men, their common interests, their common journeys, and the fact that I was able to locate them sometimes in the same city on the same day, although never in Nuremberg or Courtroom 600, where they missed each other by only a few hours, it seems that Lauterpacht and Lemkin never actually met. But the concepts they created and put into international law inform my working life, and I frequently wondered how it could be that I ended up doing the work that I do. My quest to understand Lauterpacht and Lemkin was surely in some way driven by my family history, by stories that were buried away deep in family crypts, silenced, no doubt, for the best of protective reasons. I conducted, throughout this period, a lot more family detective work, and I managed to discover who Miss Tilney was. Meet Miss Tilney. It took a long time to find her. I also understand now why my mother, my brother, and I have reason to be deeply grateful to a remarkable and courageous human being who was a missionary for the Surrey Chapel in Norwich, into which she was born, motivated by the sermons of her father, a pastor, and by Pastor David Panton. And in particular, I would discover by chapter 10, verse 1 of Paul's letter to the Romans. I have learned that this single line is what motivated her to travel to Vienna and to save my mother's life in the summer of 1939, and the lives of many people in the months that followed. I stand before you because of chapter 10, verse 1, Paul's letter to the Romans, and one person's interpretation of it. I also identified the identity of the man in the bow tie. It was a journey that took me east and then west, across rivers, across an ocean, through dozens of Austrian telephone directories, with the help of a private detective whose services I retained in Vienna, and finally cracked the code with Facebook. I'm sorry to admit it, but it is true. I ended up in an attic in Massapequa, Long Island, in New York, where the granddaughter of the man in the photograph found this photograph that would offer the key to unlocking another family mystery. A photograph taken in a garden in Vienna, probably number 4 Brahmsplatz, in the spring of 1941. My grandmother with 2 men in white socks, one of whom, as you look at it, the gentleman on the right, was her lover. I learned, in carrying out the research, that to wear white socks was an indication of sympathy with the Nazi cause, but he wasn't a sympathiser, he was actually a secret and hidden Jew. And from this photograph, I followed a train of events that led me to discover the identity of the man who was my grandfather's true love, his best friend, Max. That came as a surprise. Such efforts take years and involve the assistance of a range of remarkable individuals. You might call it personal archaeology. It also reminds me that if any of us is minded ever to have an affair, we should not exclude the possibility that 70 years later, one of our grandchildren might be able to discover with absolute precision the identity of the respective lovers. Perhaps even more remarkably and entirely unexpectedly, I learned of the direct connections between my family and the Lauterpachts and the Lemkins. I was immensely surprised to learn that my great-grandmother Amalia Flaschner Buchholz was actually born and lived in the small town of Żółkiew, the very same place where Hirsch Lauterpacht was born. Indeed, Amalia and Hirsch were both born and lived on the very same street, only a few hundred yards apart. You're looking at it. It was called Limerick Strasse back then, Limburg Street. Coincidentally, or perhaps not, Lauterpacht's only child, his son Ellie, happens to have been my first teacher of international law. That was back in 1982. He was my mentor, my colleague. I worked with him, against him, appeared before him. We worked together for 33 years until in 2015 I discovered this fact, that we shared a connection, a heritage that linked us to the street that the writer Joseph Roth would call East-West Street, hence the title of the book. And I carried on with the research and discovered that my great-grandmother, Amalia Fleischner, whose life began on the street of the Lauterpacks, would end in September 1942 in the kingdom of Hans Frank, on the same street as the Lemkins. The last street which Amalia walked down was called Himmelfahrtstrasse, the street to heaven. It was the street that led from a railway platform to a gas chamber at a camp called Treblinka. A month after Amalia walked down that street into a gas chamber, Lemkin's beloved parents, Bella and Joseph, walked down exactly the same street and into the same gas chamber. Amalia Buchholz's life, in this curious way, was bookended between the Lauterpacks and the Lemkins, as it might be said, is mine, albeit in very different ways. How does one begin to explain these points of connection? The starting point, of course, is the ideas of two remarkable human beings, Lauterpacht and Lemkin, and the enduring relevance of their ideas today. The relationship between the individual and the group is one that has been contested across the ages. Lauterpacht believed that we must always concentrate on the protection of the individual, and he would surely argue even today that Lemkin's invention of the concept of genocide has been practically useless and politically dangerous, that it will tend to replace the tyranny of the state with the tyranny of the group. And in a certain way, my own practical experience doing cases on genocide concords with that view. I have seen for myself how, by focusing on the protection of one group against the actions of another, there is a tendency to reinforce the sense of them and us, to amplify the power of group identity and association, which is a source both of sustenance and danger. How does this happen? It happens in seeking to provide a genocide, because you have to show and prove in a court of law the existence and expression of an intent to destroy a group in whole or in part. And I've seen for myself how that process tends to reinforce both a sense of victimhood of the targeted group and hatred towards the perpetrators as a mass. Ireland knows that as well as anyone. But I also understand what it was that Lemkin was trying to do. He was surely right to recognise the reality that in most, if not all, cases of mass killing, the killing is targeted not against individuals, but against human beings who happen to be a member of a group that is hated at a particular moment in time or place. Lemkin would say, and it is a powerful argument, that the law must reflect that reality, that it must recognise and give legitimacy to that feeling that we all have of association with one or more groups. I'm concerned, however, about the hierarchy that seems to have emerged, one that puts genocide atop the list of horrors, so that a mere crime against humanity or war crime is seen somehow as a lesser evil. If an American president calls something a genocide, it will be on page 1 of our newspapers. But if the president calls it a crime against humanity, if it makes it into the papers at all, it'll only be on page 13. That is the power of the word invented by Raphael Lemkin, and perhaps of our sense of association with the protection of the group. What then is the enduring legacy of these two terms? The crime of genocide, crimes against humanity, were new in 1945. Today, 75 years later, once again, a poison of xenophobia and nationalism is coursing its way through the veins of Europe and many other parts of the world. The strong man as leader is bad. I've seen that for myself on journeys to the central and eastern parts of our European continent. In Hungary and in the Ukraine, for example, where those of you who saw the film made by my dear friend David Evans, My Nazi Legacy, David also happens to be the director of Downton Abbey, will have seen me standing in a faraway field, watching people dressed in Waffen-SS uniforms, celebrating the creation of Otto Wächter's Waffen-SS Galicia Division. I've seen that sentiment too on my journeys in the making of the BBC series, The Rat Line, travelling across Europe, in Austria and Poland and other places. It really is very difficult to avoid what seems to be stirring. It really is very difficult to wonder to where exactly this will lead. The generation that experienced the horrors of the 1930s in Europe, the generation that lived through the Second World War, the generation that knows why countries came together after 1945 to create a United Nations, to adopt in Paris in December 1948 a Universal Declaration of Human Rights and a Convention on the Prevention of Genocide in this room, will soon no longer be with us. Perhaps it is the disappearance of actual memory, of actual experience, that creates a space in which our politicians can take for granted what happened in 1945. It is impossible for me to have gone through the experience of writing East-West Street and the projects that followed, an immersion in the world of the years between 1914 and 1945, and not feel an acute sense of anxiety as to what is stirring. Just 2 years ago, the man who is now the President of the United States called for a complete and total shutdown for Muslims entering the United States. The idea of targeting human beings, not because of what they've done individually, but because they happen to be a member of a particular group, has a long and terrible history. The writer Primo Levi, who spent a year in Auschwitz, put the point more crisply than anyone in the preface to his book, If This Is a Man, published in 1947. He wrote, "Many people, many nations can find themselves holding, more or less wittingly, that every stranger is an enemy. When this happens," Primo Levi continued, "when the unspoken dogma becomes the major premise in a syllogism, then, at the end of the chain, there is always the concentration camp. One thing leads to another, always." Against this background, the idea of a travel ban based on a person's nationality or religion is deeply troubling. That is why I feel so proud to be associated with this effort at Sanctuary, at this wonderful university. Experience, recent experience, teaches us to know where such a beginning can lead to, singling out people not for what they have done, but because they just happen to be a member of a particular group. There are many in this room who will know what I'm talking of. They will know to where such a beginning can lead. One thing inevitably leads to another. Closer to home, you can smell a change in the air, this move to identity politics. I heard a little bit about it over lunch, here even around Limerick. 2 years ago, the Prime Minister of the United Kingdom declared to her party conference, and I quote, "If you believe you're a citizen of the world, you are a citizen of nowhere." Theresa May has indicated also that if she could, she would take the United Kingdom out of the convention it created in 1950, the European Convention on Human Rights. Her words reminded me of one passage in Stefan Zweig's magnificent book, The World of Yesterday, published posthumously in 1942 after Zweig committed suicide. For our times, if you read one book, read The World of Yesterday. For almost half a century, Zweig wrote, I trained my heart to beat as the heart of a citizen of the world. On the day I lost my Austrian passport, I discovered that when you lose your native land, you are losing more than a patch of territory set within borders. One thing leads to another. Are there shades of Germany in the 1930s, when the Daily Mail runs a front-page story with 3 senior judges pictured who have been charged solely with doing their job of interpreting and applying English law and the constitutional requirements of Article 50 of the Treaty on European Union in the context of Brexit, and labelling 3 Court of Appeal judges as enemies of the people. One former London mayor offensively evoked Adolf Hitler as a supporter of Zionism. Another former London mayor, who went on, shockingly, to be Foreign Secretary of the United Kingdom, suggested that the European Union and Adolf Hitler somehow shared common aims. Brexit and Trump are surely a reflection of a new direction. This then is the context in which I oscillate between the views of Lauterpacht and Lemke, between the individual and the group, between the realism of Lemkin and the idealism of Lauterpacht. I can see the force of both arguments. I can recognise the tension and the struggle between the individual and the group, between crimes against humanity and genocide. It's not a tension that will soon be resolved. International law today embraces both concepts. And that's the context in which I ended East-West Street, standing at a long ago site of mass killing, at which the bodies of Lauterpacht's family and my grandfather's family still remain today, finding myself caught between my head and my heart, between intellect and instinct, recognizing the need to value the inherent worth of every human being, but also understanding that pull of tribal loyalty and the essential truth of the notion that all of us are in some way haunted by the gaps left within us by the secrets of others, but also cognizant of the possibility that the recognition of the existence of that haunting will not necessarily destroy us, but could actually make us stronger. Thank you for your attention.
Colleagues, I'm sure you are as impressed as I am with this tale, which is deeply intellectual but at the same time deeply personal. Professor Sands agreed to take some of your questions, and I think perhaps the best way to do that in the interest of time is to perhaps take 2 or 3 questions together, to which Professor Sands will give a lengthy response. So if you have any burning questions, any points you'd seek clarification on, please do not be shy.
Thank you, Professor Sands. I've just finished reading the book and I just want to commend you on it. And I studied history first year in my undergrad, and I found your book much more accessible in terms of understanding what happened over the last 100 years in Europe. I just want, and some of the questions I have, you've answered them already, but I just wanted to maybe ask you about what your thoughts were, because it jumped out to me the contrast between the 2 sons of Nicholas and the other son of von Wachter, and their two different perspectives, especially in terms of empathy for human beings. I just wanted to I wondered, that jumped out to me in particular as a common theme in your book. So if you had any thoughts on that experience of working with them as well. Thank you.
It's okay, I can shout. Thank you. I don't know why, but I've always, I don't know where I picked it up, but I had the impression that Lemkin first began thinking about genocide because of something to do with the Armenian massacres in World War I in Turkey. First of all, is that true? But secondly, if it is, sort of one imagines that sort of he was thinking about crimes against a group, partly because of sort of the evidential problems of recording what happened in Turkey during those years. So, I mean, is that the case? Was he shaped by that, and sort of was that something that influenced the way he thought about the Nazis?
Sure. Let me begin with these couple of questions. First, can I just say, as with Mairead and president of the lunch and subsequently, I always have particularly loved coming to talk about this book in Ireland. I've done a lot of different events over the past 3 years, and it is the most literate and engaged audience. I've often asked myself the question why it is, and wondered to what extent the Ireland's own connection with these issues means that they resonate in a particular way. In the book, on the first question, I describe how I've come to know both sons, Nicholas and Horst. And they're very different. Nicholas despises his father. Horst loves his father. They were both indicted for mass murder. They both basically did the same thing, although they had a different style. The first time I met Nicholas, in 2012, I looked him up because he'd written a book called Der Vater, my father, the father. And it is the longest letter of vitriolic hatred written by a son in respect of his father that I think has probably ever been written. Eventually, we met in Hamburg in the spring of 2012, and within 5 minutes of meeting him, he'd done two things. He'd taken a photograph out of his jacket pocket of his dead father, freshly hanged at Nuremberg. I was pretty shocked by that. And then he said, Philippe, I'm against the death penalty in all circumstances except in the case of my father. Later on in the conversation, he said, since you're interested in Galicia and Lemberg, I'm friendly with the son of the governor of Galicia and Lemberg, Otto Wächter, who was the deputy to my father. Would you like to meet the son? So I got to know Horst 3 or 4 months later. And Horst's position is completely different. Horst's position is that he recognises his father was part of the machine, but that he was fundamentally a decent man. And the film, My Nazi Legacy, explores the gap between those two men. And in fact, I've gone on to make this podcast series, having now known Horst for 7 years, as to exactly what happened in relation to his father. There was a moment in the film, which was made in 2015, when I'm asking Nicholas whether what concerns he has about Horst. And he says to me, what, I think Horst may become a new Nazi, which I actually disagree with. For me, Horst is a damaged child who wants desperately to find the good in the man who loved his mother, or the man who was loved by his mother. It's not about his love of the father, it's about his love of the mother. He was incredibly close to his mother. When Horst saw the film, he was incredibly upset about that line in the film, although he recognised that I said on the screen I disagreed with Nicholas's characterisation. And over time he said to me, what can I do to show that I'm not a Nazi? I said, well, I don't think you are a Nazi, but one of the things you could do is you've got this huge archive that you've mentioned to me of your mother and father's letters, diaries, and other documents. Why don't you give them to an archive? And then scholars can research them and look at them. He said, terrific idea. Which archive? I suggested the Holocaust Museum in Washington, and within a few months, they digitized and scanned everything. And he sent the USB to me. And going through that archive, those of you who listened to the Ratline will know, I stumbled across another extraordinary story. Wächter disappeared off the face of the earth in May 1945, the day the war ended. He reappeared 4.5 years later, on July the 13th, 1949, in Rome, in a Vatican hospital, dead, in mysterious circumstances. What happened in those 4.5 years? That's the story of the Ratline. The fact that Otto Wächter was never caught, although he was indicted for mass murder, crimes against humanity and genocide, has created a space in which Horst is able to excavate an image of his father as a decent man. Quite why the two men take different positions is a matter for psychologists, psychiatrists, psychoanalysts, not an international lawyer. But I think in large part it deals with the relationship between the two men and their fathers. And that emerged pretty strongly. But I've stayed in close touch with both of them. And it is a curious thing indeed that they've become a significant part of my life. The relationship with the two men is different. I've also come to know each of their children. They each have one daughter. And I've come to understand in ways that I hadn't when I was growing up, because I'd only ever seen one side of the story. You know, we grew up in a house in which my mother would not allow us as kids to have anything that was German. And so I got that side of the story. But you grow up as a kid, you mature, you begin to see things in different ways. And you know, people in Ireland and in Northern Ireland will understand exactly what I'm talking about. And I came to know Nicholas and Horst, and I understand what they had been through. And when someone like Nicholas says to you, Philippe, I remember October the 16th, 1946 really well. It's the day his father was hanged. And he described to me how, in the school playground, as a 7-year-old boy, other kids in the playground took the mickey out of him because his father was going to be hanged that day. I understood that there was that side of the story, which was as painful and as difficult for the next generations. Neither of these two men, when they were children or as adults, is responsible for what their fathers did, but they have to live with it. And Nicholas's daughter, wonderful woman who has become a good friend, Francesca, said to me one day, you know, my father tried to deal with the horrors of what his father did by telling me, when I was a young child, about how awful my grandfather was. And she said to me, and it touched me deeply, I worried that I had my grandfather's bad DNA evil gene. And I've lived with that all my life, worrying who I am and where I come from. And the moment a son and a granddaughter of a perpetrator tell you that story, you immediately, I think, as a sensitive person, just look at things in a completely different way. And in that way, despite my difficulties with some of Horst's views and some of Nicholas's views, I feel bonded by them on different sides of the same coin. They're decent human beings. And it says a lot about reconciliation, that within 2 generations, it is possible to have those kinds of relationships. You're absolutely right. The catalytic event for Lemkin was the killings of the Armenians in 1915, and he ascribes it to a moment that took place in Limerick in the classroom when what had happened was that in 1921 a young Armenian man called Soghomon Tehlirian, living in Berlin, identified as living in Berlin one of the Turkish leaders who had led the massacres. He tracked him down, found him, and assassinated him on a street, and he was then put on trial for murder. And that was very widely reported in newspapers around Europe, including in Limerick. It was a huge, huge trial. And Lemkin describes how, in the course of that period, there was a debate in one of his classes, I think probably with Makarevich, in which the professor said the state is entitled to treat its citizens as it wants. The people of a country are like chickens owned by a farmer. If the farmer wants to kill the chickens, the farmer is entitled to kill them. And the position in 1921 and the position until 1945 was exactly that. If a government decided one day, as a matter of international law, it wanted to kill everyone on that side of the room, international law had nothing to say about that. It was just a matter for the sovereign. Absolute sovereignty meant absolute sovereignty. And according to Lemkin's account, he challenged the teacher and said, no, the person who should have been punished was not Taylor, but the person who he killed. And that caused a debate. According to Lemkin, sowed a seed, but I tend to be somewhat sceptical about dear Raphael Lemkin's accounts, because as those of you who read the book know, I've caught him out on a couple of porcupines, where he claims to have been in a particular place on a particular day and been involved in a particular thing, and I discovered that in fact he was 3,000 miles away on that day and didn't attend the conference where he confronted two senior Nazis in Madrid. He was actually back home in Poland. But I suspect with Lemkin, there is an element of truth. They're sort of little white lies, and they don't change the fundamentals of the story. But you are absolutely right. That was a huge thing for him, and it catalyzed, in some way, a lifelong interest in that subject.
Thank you very much. Very powerful story you tell. And I'd like to pick up on that point that was raised by Neil there, which is that there seems to me to be a much longer genealogy of crimes against humanity and atrocities from the late 19th century through to the First World War. And you can begin this in Bulgaria in the 1870s. You can see it with the outcry against what's happening in the Congo, then in the Amazon, which obviously also involved a strong Irish input, and then the politicization of atrocities during the First World War, obviously over Armenia, but then also over German imperialism and colonialism in Namibia. So I just wonder how much the codification of genocide and crimes against humanity at Nuremberg, in fact, owed a much greater kind of debt to both a legal and a historical discourse that was happening for the 50 years previous to that. But the point I really want to make is, with regard to Nuremberg, is that in some ways Nuremberg is both a history lesson and a morality tale. And we still kind of think about it in that way. And I think your story does that in a fascinating way. But in actually thinking about it in a kind of personal perspective, do we to some extent, and I think you kind of make this in your conclusion, but do we actually avoid the larger issues at play about the relationship, in fact, of kind of liberalism to socialism?
Is there a quick response? Yes, to your first point, you're absolutely right. I mean, Lauterpacht and Lemkin were able to do what they did because of a growing sense of consciousness in the decades before that allowed them to think, okay, how do we take these ideas and recast them as legal rights and obligations in binding international law? What they did was essentially take ideas that pre-existed and put them, it was a sort of act of camouflage. Crimes against humanity was used in diplomatic exchanges, for example, in 1915, but not as a legal concept, basically as an idea. So absolutely they did that. But you can go back even further. I mean, because of time, I left out a little bit of the lecture, but I also do a musical performance with an opera singer and a pianist and a German actress. And the central part of that performance in east-west street with music, so to speak, is the Matthew Passion by Bach. Why? Because the Matthew Passion, an 18th century piece of music, is also about the individual and the group. You can interpret the Matthew Passion as an attack by a pietist Johann Sebastian Bach and his librettists on the Roman Catholic faith. Where do you see that? Every aria but one is sung in the first person. The three best known choruses are sung in the first person. Why is that done? That is, in various interpretations, Bach signalling the bypassing of the individual human being's relationship to God, the bypassing of the group, the priest-celebrant, and the direct connection. So I certainly don't take any credit for originality, finding these connections in law on the individual and the group. You can trace it back well beyond the 19th century into ideas that go back to religious discourse and struggle. What I was interested in, coming to the point about the personal element, was this. And it comes from my work as a barrister, sitting in court for days and weeks, watching what is going on, and coming to understand that in the cases that I do before international courts, individuals really matter. Individual judges, individual witnesses, individual counsel, individual experts. The law books that I read and taught with at universities sort of describe things like Nuremberg in a mechanical sort of way. States decided to draft the statute. The court then decided to apply the law to the facts in the following way. This was the consequence. But I know from the reality of my life in the Peace Palace in The Hague that that's not how it works. When I'm preparing a case at the International Court of Justice, appearing before 15 judges, I and my colleagues spend hours and hours and hours trying to understand the propensities of the 15 individual judges. The law is not something that is mechanically applied. You know this in the courts in Limerick, there may be some judges here, you know it in the courts in Dublin, you know it in courts throughout Ireland. That the judge you find yourself appearing before makes a huge difference, that we bring to the process of interpretation and application, without being biased and without lacking independence, our own personal baggage. I sit now as an international arbitrator. I'm acutely conscious that I come to a fork in the road on a decision and I might jump one way or the other way. And the act of jumping one way or the other is informed in some way by factors that I bring to that process. And what I wanted to understand was how it was truly that these concepts came to be argued at Nuremberg. And I stumbled across this completely accidental but astonishing story that started with a search for my grandfather's house, where he was born. That's really what I wanted to find. And discover, by amazing coincidence, or perhaps by other means, that's one of the debates we have at home around the kitchen table. How do you explain the fact that I stumbled across this story? Is it just total coincidence? Or are there other forces at play that caused this to happen? Whatever your answer is to that question, the fact is, personal stories matter. Lawyers, and in particular law professors, are very uncomfortable with that idea because it has the effect of demystifying the law. Reverence for the law is premised on the idea that it is neutral, that it's mechanically applied, that it's independent, that it's impartial. I think the story that I wanted to tell is that life is not quite like that. And we need to scratch below the surface to understand the reality of why things happen. The bottom line is, it may have been other people, but for Lauterpacht and Lemke, those moments would have gone differently. There would not have been a concept of genocide. The word would not have existed. And I doubt that crimes against humanity would have made their way as a legal concept into the Nuremberg statute. And every single case I have done on crimes against humanity and genocide leads back in some way to that moment in the Nuremberg court. And hence, it is useful and vital to understand, I think, the personal element. That personal element touches on the issue you raise: liberalism, socialism, communism, what other form of governance we want. Because the two individuals brought to their process of articulation of crimes their own values about the individual and the group, and their place in society, and the balance between the two. But a full lecture on that, we'd be here for hours, so I'd better stop.
I'd now like to invite President Fitzgerald to present Professor Sands with a Medal of Honour at close proceedings.
Dave, thank you very much. This is the first of a series of lectures under UL form, and I was about to say you epitomise what we had in mind. In fact, you've gone far beyond that, and I want to present you with a medal, the UL form President's Medal, in the hope that you will remember this evening, as I'm sure everybody here will. Congratulations. Thank you very much. Everybody for coming here tonight. I want to particularly thank our former Chancellor, former Chief Justice John Murray, and our Deputy Mayor who's here tonight, Marion Hurley. And I also want to thank Shane and for introducing Philippe tonight, and also to Mairead, who heads up our Sanctuary Programme. And tonight's lecture is under the Sanctuary Programme. And lastly, just to thank Michelle Holden, Ailish Nagel, and also Eamon Cregan, who helped put the programme together. Thanks everybody, see you next time.